Supreme Court just changed Social Security forever. 9-0 ruling nobody is talking about. 9 justices, 0 disagreement, and every single retired American in all 50 states is about to feel the impact of what just happened inside the highest court in this country. This is not a political story. This is not a left versus right argument. This is a unanimous decision, meaning the most conservative justices and the most liberal justices sat down together, looked at the same evidence, read the same law, and came out the other side agreeing completely. That almost never happens in a court as divided as this one has been for decades. A 9-0 ruling is not just rare, it is historic. And the fact that you probably have not heard about this yet is exactly why you need to stay right here until the very last word. What the Supreme Court just decided reaches directly into the retirement security of millions of Americans who spent their entire working lives paying into a system they were promised would be there for them. We are talking about Social Security benefits. We are talking about the money that older Americans depend on every single month to pay rent, to buy groceries, to cover prescription medication, to keep the lights on. And this ruling changes the legal framework around how that money is protected, how it can be reduced, delayed, or denied, and what rights you now have if the government tries to interfere with what you are owed. Before this ruling, there was a quiet but growing pattern happening inside federal agencies that most retirees never knew about. Administrative decisions were being made about Social Security benefits with almost no meaningful way for ordinary Americans to challenge them. The process was buried in bureaucratic layers. The appeals were slow. The outcomes were often predetermined. Retired Americans who had been wrongly denied benefits or who had seen their monthly payments reduced without clear explanation found themselves trapped inside a system that seemed designed to exhaust them into giving up. And many of them did give up, because fighting a federal agency when you are living on a fixed income, when every month matters, when legal costs alone can eat through your savings, is not a fight most people have the energy or resources to wage. That is the world that existed before this ruling came down. The case that changed everything. And here is where the story of one ordinary American changed everything for every retired person in this country. There was a man, a retiree who had worked for decades, paid into Social Security his entire career, and reached retirement age expecting to receive exactly what he had been promised. Instead, the agency responsible for administering his benefits made a series of administrative decisions that reduced what he was owed. He challenged those decisions. He went through the internal appeals process the way he was supposed to. He followed every rule. He filed every form. He met every deadline. And at every step, the agency used its own interpretation of its own rules to rule against him. The system was essentially grading its own homework and giving itself a perfect score every time. So he took it to federal court. And then it went higher and higher until it reached the Supreme Court of the United States. And when those 9 justices looked at what had happened to this man, when they examined how federal agencies had been operating with almost unchecked power to interpret the laws governing Social Security benefits in whatever way served the agency rather than the retiree, they did not split 5-4 the way the country expected. They did not divide along ideological lines the way every other controversial ruling seems to do. They agreed, all 9, completely, unanimously. What the Supreme Court actually decided. The core of what the Supreme Court decided comes down to a principle that sounds almost too simple to be the center of a landmark ruling. The principle is this: federal agencies do not get to be the final word on what the law means when it comes to the benefits you are legally entitled to receive. For decades, something called the Chevron Doctrine had given federal agencies enormous power to interpret the laws they administered. What that meant in practice was that when there was any ambiguity in a law related to Social Security, the agency responsible for running that program got to decide what the ambiguous language meant, and courts were told to defer to that agency interpretation as long as it seemed reasonable, not whether it was correct, not whether it was fair to the retiree, just whether it seemed reasonable to the people inside the agency making the decision. Think about what that actually means for a moment. Imagine you have a contract with someone, a real legal contract that says they owe you money every month for the rest of your life. And then imagine that whenever there is any dispute about what the contract means, that other person gets to be the judge. They get to interpret every unclear word. They get to decide every close question. And the court is told to go along with whatever they decide unless it is completely unreasonable. That is what retired Americans were living with before this ruling. That is the system that was in place while millions of people tried to fight for benefits they had earned over a lifetime of work. The Supreme Court looked at that arrangement and said it cannot stand. Courts are supposed to say what the law is. That is their job. That has always been their job going back to the earliest foundations of American constitutional law. When a federal agency makes a decision that takes money away from a retiree, or reduces their monthly payment, or denies their claim, and that retiree challenges that decision in court, a judge must now apply genuine, independent legal analysis, not rubber stamp whatever the agency decided, not defer to the agency simply because the agency has expertise in running the program, actually read the law, actually determine what it means, and actually protect the rights of the American citizen who is standing before that court, asking for what they were promised. This is the shift. This is what 9-nail looks like when it lands in the real world of retirement security. Why this matters for your retirement right now. If you are currently receiving Social Security benefits, or if you are within 10 years of retirement, or if you have a spouse or a parent who depends on those monthly payments, this ruling is not an abstract legal development happening somewhere far away from your life. This is the architecture of your financial security being rebuilt on stronger ground than it has stood on in decades. Here is something that most coverage of this ruling is completely missing. The impact is not the same in every state. Because Social Security Administration involves both federal rules and state-level implementation in certain programs, the practical effect of this ruling on your specific situation depends partly on where you live. Some states have been more aggressive than others in using administrative interpretation to limit certain categories of benefits. Some states have larger backlogs of denied claims sitting in the appeal system right now. Claims that were decided under the old framework where agencies held all the interpretive power. Those pending cases are now being looked at through a completely different legal lens. And in those states, the number of retirees who may now have legitimate grounds to reopen their cases, to challenge past decisions, to demand that a court actually look at whether the agency got the law right, is significant. This is not a promise that every denied claim will be reversed. This is not a guarantee that every retiree who was shorted will automatically be made whole. What it is the opening of a legal door that was shut for a very long time. A door that stands between ordinary Americans and the retirement security they spent their working lives building. And the Supreme Court just propped it open with a unanimous ruling that no future administration, no agency director, and no federal bureaucrat can simply ignore. Which states are most affected? Start with the states that have the highest volume of Social Security disability and retirement benefit disputes, currently sitting inside the appeal system. States like Florida, Texas, California, Pennsylvania, Ohio, Michigan, Georgia, and Illinois carry enormous retiree populations. These are states where tens of thousands of benefit claims have been denied, reduced, or delayed over the past several years. Many of those decisions were made by administrative law judges operating inside the Social Security Administration itself. Under the old Chevron framework, when those decisions were challenged in federal court, judges were told to give significant deference to how the agency interpreted its own rules. That deference is now gone. Every one of those pending challenges and every new challenge filed going forward will now be evaluated by a federal judge who is required to make an independent determination about what the law actually says and whether the agency got it right. That is not a small shift. That is a fundamental rebalancing of power between the federal government and the American retiree. Dark A, the 3 benefit categories. Most impacted. Let's talk about the categories of benefits where this ruling has the sharpest and most direct impact. Category 1, Social Security Disability Insurance, SSDI. The denial rate for initial SSDI applications has been extraordinarily high for years. A significant portion of those denials come down to how the agency interprets the medical and functional criteria written into the law. Those interpretations have historically been given enormous deference by courts. That deference is now removed. If you were denied SSDI benefits, and you believe the agency misread the legal standard that applies to your medical condition or your functional limitations, you now have stronger legal footing to press that challenge in federal court than you have had at any point in recent memory. Category 2. Survivor benefits. When a spouse passes away, the surviving partner is entitled to certain Social Security survivor benefits based on the deceased spouse's earnings record. The rules governing these benefits are written in federal statute, but for years, the agency has had wide latitude to interpret edge cases, particularly around marriage duration, timing of claims, and coordination with other benefit programs. Under the new framework established by this unanimous ruling, those interpretations are no longer automatically shielded from judicial scrutiny. If a surviving spouse was told their benefit amount was calculated a certain way because of the agency's interpretation of an ambiguous rule, a court can now look at that independently and reach its own conclusion about whether the agency was right. Category 3. Retirement benefit timing and reduction rules. There are complex provisions in Social Security law that govern how benefits are reduced when someone claims early, how benefits interact with pension income in certain cases, and how benefits are calculated when someone has worked in jobs not covered by Social Security for part of their career. These provisions have generated enormous administrative interpretation over the years. Some of those interpretations have cost retirees thousands of dollars annually. With the Chevron deference framework now dismantled, challenges to those interpretations stand on fundamentally different legal ground than they did before this ruling came down. What this means for future benefit decisions. Here's the part of this story that most coverage is completely overlooking, and it is the part that connects directly to the long-term financial security of everyone reading this right now. This ruling does not just affect people who are currently in a dispute with the Social Security Administration. It changes the environment in which every future benefit decision will be made. Agency officials and administrative law judges inside the Social Security system now know that their interpretations of the law are subject to genuine independent judicial review. That knowledge alone changes behavior. When decision-makers inside a bureaucracy know that a federal judge will actually examine their work rather than simply defer to it, the quality and fairness of those decisions tends to improve. The accountability that this ruling creates is not just legal, it is institutional. It reaches into the culture of how these agencies operate day to day. Think about what this means for someone who is currently 55 years old and planning for retirement in the next decade. The decisions that the Social Security Administration will make about your benefit amount, your eligibility, your claiming options will now be made inside a system where independent judicial oversight is real and meaningful. The agency cannot simply adopt the interpretation most convenient for its administrative purposes and count on courts to wave it through. Every significant interpretive decision now carries the weight of potential judicial scrutiny, and that scrutiny will be applied by judges who are required to read the law themselves, not simply accept whatever the agency says the law means. Addressing common misconceptions. Now let's deal with a misconception that spreads quickly whenever a ruling like this comes down. Some people hear about a Supreme Court decision that limits agency power and immediately assume it means the government is about to cut Social Security benefits or reduce program funding. That is not what this ruling does. This ruling does not reduce any benefit. It does not authorize any cut. It does not give Congress or any administration new power to shrink the program. What it does is the opposite of that. It gives individual retirees stronger legal standing to challenge decisions they believe are wrong. It shifts interpretive power away from the agency and toward courts that are constitutionally designed to be independent. For retirees, this is a protection, not a threat. Checkers, can you reopen an old case? There is also a practical question that many retirees and near retirees are asking right now, and it deserves a direct and honest answer. If you had a benefit claim denied or reduced in the past, does this ruling give you a path to reopen that case? The honest answer is, it depends on where your case stands procedurally and how much time has passed since the decision was made. Federal law has specific deadlines for challenging agency decisions, and those deadlines do not disappear because of a new Supreme Court ruling. What this ruling does is change the legal standard that applies to challenges that are currently pending and to new challenges filed going forward. For older cases, the path back is narrower, but not necessarily closed. There are legal mechanisms, including motions based on changed legal circumstances, that attorneys who specialize in Social Security law are actively exploring right now on behalf of clients whose cases were decided under the old framework. What 9-0 really means. What does all of this mean when you bring it back to the most important number in this entire story? 9-0. Every justice on a court that has been bitterly divided on nearly every major question for years looked at the question of whether federal agencies should have unchecked power to interpret the laws governing your retirement security and said no, unanimously, without a single dissent, without a single reservation significant enough to produce even a partial disagreement. The strength of that consensus is itself a message to every federal agency, every administrative law judge, every bureaucrat making decisions about the benefits of retired Americans. The message is that the courts are watching, that the law means what it says, and what it says will now be determined by judges who are accountable to the Constitution, not by agencies that are accountable primarily to their own administrative convenience. The bottom line: if you have been paying into Social Security your entire working life, if you are planning a retirement that depends on receiving what you were promised, if you have a parent or a spouse whose monthly benefit check is the difference between stability and hardship, this ruling is the most important legal development in the retirement security space in a generation. 9 justices, 0 disagreement, 50 states affected, and a retirement system that just got a stronger constitutional foundation than it has had in decades. That is the story. And now you know. If this information helped you understand something you weren't hearing anywhere else, share it with someone who needs to know. Drop a comment below and tell us which state you're in and whether you or someone you know has dealt with a Social Security benefit dispute. The conversation happening in comment sections matters, and every single voice gets heard.